I like everybody I've met over the last year. I enjoy helping the public when I can. I enjoy getting the bad guys off the street when needed. Why do I want to remain magistrate? For the love of the job and all it stands for. Thank you.
Thank you, Tim. I got a notification there what I was sidetracked with. We appreciate your answer, Tim, and thank you. But apparently our live feed dropped out for just a moment, so we're going to stall for just a second. It will be captured in the video, so it will be shared. And also Mr. Gougeot has joined, and so we want to recognize him. His audio is still connecting, but we're just working through the bugs, folks, so please stick with us. I'm told now our feed is back live, and I don't think, Mr. Pocious, many of your comments were missed. I don't want to make you have to readdress it if you don't want to, but I don't want to deny you the platform to speak. So if you want to take a moment and recap what you said, we'll welcome you to do that. Just so it's on the live feed again.
Sure. I mean, I can just recap that, you know, I am magistrate now, and I want to continue to be your magistrate, and I do take the job seriously, and I want everybody to know that I am working on this job, not a 9 to 5, Monday through Friday. I am here 24/7, working hard. And the reason is because I love the job and I like what it stands for. Thank you.
Okay, very good. Thank you for that. I'm sorry that we had that technical problem, but thanks for your recap there. Mr. Gougeot, joining just here with us for a minute. We are underway answering questions. What we'll do, I'm going to unmute you for just a minute. What we'll do is we'll go ahead and get through the rest of our questions and bring you back into the rotation. But we'll give you an opportunity to introduce yourself when you address your first question, okay?
Difficulties with this right now.
Okay, his audio is obviously not working, and so welcome to a brave new world, folks. We're all learning this together. So,
Can you hear me?
No, you're very very distorted, like there's something wrong with your microphone. Okay, so let's move on to Ms. Holpit answering our first question for a magistrate. Ms. Holpit, or Mrs. Holpit, please tell us why you want to remain as a magistrate. Well,
do you hear me?
Sure, go ahead.
Oh, okay. I love what I do. I love serving the people of Monongalia County. We have the busiest county in the state rather than Kanawha County. And every day is a learning experience and a challenge. For example, last year, we had some real issues. We had a magistrate that had medical issues. We had a magistrate suddenly retire. We had a magistrate on vacation. And I ended up being last man standing, so to speak, last woman. And I was it from Monongalia County. So I worked 24 hours every day, up to 7 days, before anyone came back and was able to take over their duties. So that was a challenge. And I was up for it because I am dedicated. It is a job that you have to do.
I'm sorry, Mrs. Smith. Hold on one second. Mr. Gougeot, your microphone is not working out. And as you unmute yourself, it's overriding of someone who is speaking. So I'm going to go ahead and mute you. And we'll try to get you some tech help, but when you unmute yourself, it's overriding a speaker that's already speaking. Okay, Mrs. Holpit, go ahead, please.
All right, I'm sorry. I'm not sure how much of that you got, but the court system here in Monongalia County is very busy. That's the point. And I'm very dedicated. I stepped up to the plate when I was needed. I worked 24 hours a day, 7 straight days, nonstop. And then we did get some help. And it was a trying year. It was very busy. We had issues here. And then this year, we have the coronavirus. So you never know what to expect in magistrate court, but it is always a learning curve. It's always a challenge. And that's what I enjoy. I enjoy being challenged. I want to know how far I can go and how good I can be and how much I can step up to the plate and do my job. And I do. 12 years ago, I promised the citizens that I would always put the citizens' safety first. And I kept that promise. I also promised the citizens that I would be the voice for children and animals when they didn't have a voice in our court. And I keep that promise. And I always promised that no matter what, I would strive to do my very best and make a difference in our county. So I try to inspire people. I try to be a very good example. And I believe that I have done a very good job with that. To give you an example, I work very closely with the police. They're in magistrate court all the time, all the departments that we have. They know what kind of a job I do. And I am very humble to say that the Fraternal Order of Police, Lodge 87, did endorse me for re-election. You know, the most gratifying part of this job is when you do make a difference. I've had moms, dads, brothers, sisters, and even defendants come in or write me a letter and say, thank you. You did this for us. Thank you. A while back, I had a young man walk into my courtroom and he just came right up to the bench to me. And he said, Magistrate Holpit, do you remember me? And I looked at him and I said, you look very familiar, sir, but I'm sorry. We see a lot of people here. He said, well, you know what? He said, a year ago, I hated you. He said, I really hated you. He said, but I had to come in here today and shake your hand and thank you for what you did. And he said, basically, you saved my life. And he shook my hand. And that meant more than anything in the world to me, that I was able to do something to help this young man. And I wouldn't give this job up for all the money in China. So I'm hoping that the voters know the kind of job that I've done. I hope they know how dedicated I really am and how much I want to continue to do this work. So I'm in Division 4, and I'm asking for everybody to vote for me again so I can continue to make a difference.
Yeah, very good. Thank you, Magistrate Holpit, for that thoughtful answer. Our next respondent will be Mr. Reyes. And go ahead, Mr. Reyes.
Good, thank you very much. I've been in public service now in this county for about 40 years. First as a state trooper in this county, and the last 20 some years as an assistant prosecuting attorney. After I graduated from law school in 93, started in the prosecutor's office in 97. And during the course of that time of my law career, I've had the occasion to try criminal cases, civil cases in both magistrate court and circuit court. And I've also appeared before the West Virginia Supreme Court of Appeals. And I think I'm proud to say that during the course of the time I had as a prosecutor, I was the prosecuting attorney, assistant prosecuting attorney who handled magistrate court for those 20 years of my career. So I pretty well know all the ins and outs of magistrate court, the individuals that we deal with, some of them, unfortunately, on a continuous basis. So I pretty well know what's going on in the court and pretty much outside of the court. And so through my experience and education and knowledge of the court system, and not only that, but the individuals that we deal with on a daily basis in magistrate court, I think I developed a well-rounded, might call education of what to do in the cases in magistrate court. And just because I was an assistant prosecuting attorney doesn't mean I haven't had the opportunity to help defendants. There are various defendants out there in the county right now that I have helped get them through situations. And thankfully, they've made a big turnaround in their lifetime. And like Magistrate Hope, they've come to me just shortly before I retired from the prosecutor's office, thanking me for changing their life. And so I think what I missed when I retired from the prosecuting attorney's office was public service and the people, and serving the people of this county, which I've done for over half of my life, really. And I just love doing that. That's what I'm good at. And I hope the voters of this county see that in me. And the people that know me know that's what I try to do every day of my life. I try to do the right thing and live by that code every day. So I hope they see that. And that's basically why I want to be a magistrate. So I think I can help the people of this county, make this community a better place to live in, and kind of maybe streamline some of the court procedures that are going on and make that a more efficient court system of the magistrate court. Thank you.
Very good. Thank you for that answer. Mr. Bain is up next, answering the question that's been posed. Why do you want to be a magistrate? Mr. Bain?
How you doing? I'm going to move back a little bit. We got a little graphic here. So, one of the things I want to stay with the question. The question is, why would I want to be a judge? Well, I've been committed to public service for 20 years of my life, and I've been on a lot of different things. I've been on city council. I've been on the transit authority. I've been on MUB. Been on the traffic commission. All my life, I've been trying to do those things and help out my community. I love Morgantown and I love Mon County. I'm a 6th generation person here. We looked back on ancestry.com, and I'm related to Thomas Chips, which came here in the late 1700s. So it's pretty cool to be able to be a part of Mon County's future, and that'll be my one of the things that are there. But I'm committed to community service. I'm also committed to looking for the best ways that we can make this community the best thing for families. Our future is families. Our future is making a place that everybody feels safe. And one of the things that we can be on the front lines, just like Magistrate Holpit said and Magistrate Pocha said, you're on the front line, and you get to see some of the things that are going on in this community that you can actually make a difference in those people's lives and make a future for families here. So, those are my bullet points there. I had a Reverend Ramsey when I went to Wesleyan Church downtown. He always said, let's make 3 points. So mine's commitment to community service. Let's make families feel safe here, and let's look to the future and make it the best we possibly can. So that's it. Thanks.
Very good. Thank you for that. Paula, I'm going to ask you to step on for a minute and ask the next question. We're up to question 2, and we'll start with circuit court judges and candidates. So Paula, are you on?
I'm right here. So I will start with question number 2 for our circuit judge candidates. And that is, to what extent do you believe that a judge should or should not defer to the actions of the legislature? And let's start with Cindy. I believe you were first before. So go ahead, Cindy Scott.
The previous order had Michael Sims going first. I can do whatever you would like, but if you want to follow the script, it would be Michael Sims.
Okay, let's go ahead and do it that way, Cindy. Thank you. I appreciate that. I wasn't remembering the order. So we did Michael and then you and then Deb. Is that what it sounded like?
Yes, that is correct.
Okay, we'll do it that way. So let me read the question again for Michael. To what extent do you believe that a judge should or should not defer to the actions of the legislature? Hold on, I gotcha.
Can you hear me?
Yes, thank you, Michael. Sorry,
Sure.
I couldn't get to the unmute button here.
That's okay. Okay, so the question the committee posed, to what extent do I believe that a judge should or should not defer to the actions of the legislature? So first thing, I don't believe in judicial activism, okay? My sworn oath is to apply the law fairly and evenly to everyone who comes before the court. I believe in the separation of powers, and I believe in the Constitution. And Article 8, Section 6 of the West Virginia Constitution discusses the authority and the power for our circuit court judges. And there's no place in that section where it discusses some power to usurp the wishes and the will of the legislature. Okay, so that's how it works. Systematically, that's how it works, and that's how I feel about it. The other point that I want to make is the question is really incomplete because it makes an assumption that the law only comes from the legislature, but that's only one source of the law that we as circuit judges look to make decisions. So we also have primarily something called the common law, and the common law it's the body of law, or the decisions that come from our West Virginia Supreme Court primarily, but also from the United States Supreme Court. And so those two things together, plus another source of law in West Virginia, which would be administrative regulations. We have a whole body of administrative regulations that also carry the force and effect of law. So, you know, as a circuit judge, it's not just the will of the legislature, you know, reading a statute and adhering to the plain language, but we also look to our common law when we want to understand, well, what did the legislature mean when they wrote this phrase? How has this been interpreted by courts in the past? And, you know, the source of the law is broad. It's broader than just the statute, but my job as a circuit court judge is not to create precedent. Precedent is a decision that was made by a higher court that we're bound to follow. And so what we do is we look at the plain language of the statute, we look at the plain language of the applicable rules, we look at the common law, and we apply it to the facts that are in front of them. And that's exactly what I would do as circuit judge.
Thank you, Michael. Cindy, I'm going to have you up next. I'll read the question again, but thank you. You'll have to unmute yourself. I thought I could do it from here, but I can't. So let me read the question again. To what extent do you believe that a judge should or should not defer to the actions of the legislature?
And I agree with exactly what Mr. Sims just said. I also am not a proponent of judicial activism, and I believe that a judge should refer to the decisions that come out of the legislature. I would want to maintain the impartiality of the judicial system and would never want to be skewed or viewed as someone that had a different goal other than treating fairly and correctly the citizens of Monongalia County. I don't believe that a judge should enforce their own views, but I think that they should defer to the legislators who were elected to serve in that capacity. They were elected to make the laws. A judge is elected to enforce the laws, interpret the laws, and that's what I would do. I think there's also a layer of protection there when you look at the fact that those decisions could be appealed to the Supreme Court. I think that's where the case law that Mr. Sims was talking about would be generated. That's the purpose of the Supreme Court. Any aggrieved party has the opportunity to take their case there for review. If the decision was made incorrectly, it would be corrected at that particular stage. Supreme Courts also serve in the capacity of determining if those laws are unconstitutional or vague or need additional clarification. And so I believe that it is very important to honor what the citizens elect. They elect legislators to serve in that capacity, and they elect judges to serve in this capacity. I also think it's very wrong to legislate from the bench or to engage in judicial activism because it kind of switches the burden to the litigant. The litigant's there to present their case and to get a fair and efficient and quick ruling. not to have the cost imposed on them for that case to go longer or further because the judge had a different goal in mind. And so that is my position. I would defer to the rules and the laws that are imposed and passed by the legislature. And I believe that's the fairest and the most effective way for a judge to serve this county. Thank you.
Thanks for your response, Cindy. And we finally have Deborah Scudere, sorry. The question again, to what extent do you believe that a judge should or should not defer to the actions of the legislature? And if you would unmute yourself, Deborah, can you do that? The very bottom left corner is a mute button, and if you click on it, it'll unmute you.
Gotcha. Thank you. Legal issues have to be decided by a judge every day. Judges have to follow the law. Laws are there for a reason. The public has to know what is and is not lawful. A judge cannot make up the law on the fly, sitting on the bench. Most lawyers who appear in front of me pretty much know ahead of time whether I'm going to rule in their favor or not, because they know that I have to follow the law. My rulings are usually not a surprise to them. Our system of government divides itself into three parts. The legislature makes the law, the courts interpret the law, and the executive branch carries out the law. It is not my job to tell the legislature what laws to pass. Since I've been on the bench, I have ruled in some cases where the law was very complicated. In those cases, I have had to really delve into the legal issues that were presented to me. In a couple, in my own heart, I have not been thrilled with where that path led me. But looking back, in every one of those decisions, I have followed the law. I have laid aside my personal feelings, and I, as the judge, have done what I saw to be right. It's not always easy. Sometimes it's almost agonizing, but I do what I have to do, and I can live with myself in the process. If a party against whom I have decided an issue still disagrees with my ruling, his perfectly appropriate remedy is to appeal that ruling to the West Virginia Supreme Court of Appeals. If the Supreme Court came back to me and said that one of my rulings was incorrect, I'd readily admit that they probably know more than I do, and I would adjust my ruling accordingly. So far, I have not had the Supreme Court come back to me and tell me that I had to change any ruling that I have made. America has a great system of justice. The legislature does its job making the laws, and I do my job as chief judge ruling on those laws. I'm perfectly comfortable with that. Thank you.
Thank you, Deborah. We'll move that. I believe that's everybody, and that was our second question. So I'm going to move on to the second question for our magistrate candidates. And I apologize, I don't have the original order for that either. So do we remember who was first? Was that Stephanie?
Sandy.
Sandy, all right. Sandy, we will start with you then. And the second question is, what factors would you consider in granting and setting bail amounts for criminal defendants? So what is that primary consideration that you use? And you will have to unmute yourself in the bottom left corner of the screen.
All right. The West Virginia Code 62-1C-3 gives us the guidelines to setting bond. Number one, we have to look at the seriousness of the offense charged. Number two, previous criminal record of the defendant. Number three, the defendant's ability to post that bond, their financial ability. And number four, the probability of whether or not the defendant is going to appear in court. Those are the things that we base our bond on. Now, let me give you an example. Let's take a domestic case. a person is charged with doing bodily injury to another person, perhaps even sent that person to the hospital. I have to look at that as how serious is that? And then what I normally do in my courtroom is I go into our system and I do a background check, criminal history check. I want to know how many other domestic batteries this person has been charged with, or maybe even pled to. Or are there any other factors of violence? Could be battery, could be abuse of children, anything related to that violence. I look at their criminal history. And of course, the defendant's financial ability always comes into play, because under the Constitution of the United States, everyone has the right to be able to post bond, everybody. And the probability of the defendant coming to court. Well, if they're local and they have a job here, family here, pretty much they're going to end up coming to court. But let's go back to the domestic issue. I have to look at the seriousness, and I have to look at the criminal record and what's the probability of placing citizens in more danger by doing my job badly. So there's a lot of factors involved here. Now, we also have a tool that's offered to us, and I've used it occasionally. You can use a home confinement as a condition of bond. For example, if I don't believe that this offender, possible offender, alleged offender in a domestic case is going to stay away from the victim, then I can put them on home confinement and keep them tracked where they don't have any contact with that person. That protects them from future charges, and it protects the alleged victim from any possible future encounters. So there's a lot of factors that go into posting a bond, but those are the four that the code gives us. That's what we go by. If it's a capital offense, however, that would be like murder or kidnapping. We do not have the authority to post a bond. We do the arraignment, but the bond goes upstairs to the circuit judge, and they are the ones that post bond on those charges.
Thanks, Sandy.
You're welcome.
Thanks, Paula, for stepping in. We're going to take a pause for a moment. We do have one question that's come in on Facebook. Let me get back over to it. It was on the previous post, of course. We'll catch that question here in just a minute. Paula, where were you in the order, and what's our next question?
The next is Ron Bain, and the question is what factors to consider in granting and setting bail amounts for criminal defendants?
Okay, go ahead, Mr. Bain, and in the meantime, we'll get that public question brought in and ready to read.
Okay, the same thing. You can see the graphic there. You know, I did some research on this. I wanted to be prepared for this. So you can see there's 7 factors. Now, Sandy already said about the factors for the state of West Virginia, but I also went and did my own research on this to see all the factors that could go into this. And she touched upon all those. So I'm going to go through them. You know, I mean, we're not going to, I don't want to, you know, go over something that she already has. You know, posted bail schedules. Those are bail schedules for the specific crime, or and a specific amount typically is something that is within the law. And then the seriousness of the allegation, just like Sandy was saying, you know, you're going to weigh that on the amounts if it's going to be lower or higher. Past criminal record or outstanding warrants. You know, that's number 3 there. You know, that's something you're going to look at, and it's going to really affect my judgment on that. And then the defendant's ties to the community. Does he have, or is he invested, or she is invested in the community? Are they a known risk, or they are not, or a lesser risk? And then number 5, the probability the defendant will show up to court, and that's what Sandy had said. And then risk to public safety, huge. I mean, I think that's one of the things we have to look at, the seriousness and the danger to others in the community. Just like I was saying in the first question, how we make this place safe. And this is one of those things on the front line that a magistrate can do. And then also the potential flight risk. are they going to show or appear, or are they going to take off? So I'm not going to take the full 3 minutes, because I think this question, once we get through the factors here, it pretty much says for itself. And I think Sandy illustrated it very well. So I'll pass it on to the next person.
Thank you, Ron. Our next respondent will be Mr. Reyes, answering the same question.
Okay, thank you. I don't want to repeat things that have already been said, but there are those factors that have been brought up by Magistrate Holpit are usually the factors that are used, through my experience when I've been in magistrate court, that are used to set bail. But I think the one overriding factor that a lot of people forget about is the overall safety of the community, based upon the crime that individual is alleged to have committed. And so that's one that I think is primarily of great importance in the community. Also in West Virginia, we don't have posted bail schedules. The magistrates are, except for capital cases, as Magistrate Holpit stated, have the authority to set bail from $1 to whatever the amount they think is deemed necessary, according to the nature of the crime, the seriousness of the crime. But also, even if the bail's set and the defendant thinks that it's unreasonable, once his attorney is appointed, they can make a motion to the circuit court judge to have that bail reduced. So there's a lot of protection for defendants as it comes to bail in West Virginia. And most of the time, very rarely do I've ever seen cases where bails have been set what I would call unreasonable. But magistrates do have to balance that fine act between a defendant's right to have reasonable bail set and the safety of the community at large. So it's kind of a sometimes tough decision to make based upon the crimes that the defendant is charged with. But overall, I think the most important one is the safety of the community. I think that should be primary. And then there's other factors come into play, such as the ability of the defendant to post bail and those factors. But that's why they speak about the seriousness of the crime. The number of crimes also that an individual is charged with at the time of arraignment also comes into play there also. So thank you very much.
Thank you, Mr. Reyes. Our next respondent will be Mr. Pocious with the same question.
What I look at with bond is I'm looking to assure their appearance in court. I also look at the severity of the crime. I can give you experiences here. I've arraigned people that have been brought in on possession with intent to deliver. And in going over the paperwork with them, doing background checks, criminal records and such, find out that they're not from the area. They are Detroit, New York. And upon questioning, find out they have no ties to the area whatsoever. That's a red flag for me. That's a highly likely that we're not going to see them again if we don't do an appropriate bond for that. On the other end of that scale, I would say that I've also had experiences where 21-year-old young man brought before me for a DUI, out with a few friends, had too many drinks, talking to him, checking his background, no criminal history whatsoever. He has ties to the community. He has a job here. His family is here. I don't look at that as a huge flight risk, so I would adjust his bond accordingly to that. I think that second part of that question about the primary consideration is I will reiterate what everybody else has said. Is it a violent crime? Is there a victim involved? And for public safety, victims' safety, I would adjust the bond accordingly for that. Thank you.
Very good. Thank you for your answer. Next up is Mr. Gougeot. And Mr. Gougeot, this will be your first opportunity to address the group. And so I'm going to unmute. Mr. Gajot has had to call in with his phone, so I'll unmute. I'm going to unmute your phone.
He needs to maybe mute his video feed.
I do have him on mute, but
Okay.
got his phone unmuted.
Now?
No, it's still very robotic. So, okay, while he's working on his issue there, we'll go on to Stephanie Nethkin answering that second question. 1 second, Stephanie. Okay, go ahead, Stephanie.
So I would just echo what a lot of the other candidates have stated, that you do follow those 4 factors within the West Virginia Code. However, I'm gonna kind of give you a little bit of insight as a criminal defense attorney. Basically, magistrates are setting this bond, and if it's a high profile case where the newspaper is there and they're covering it, it seems like they're more likely to bump up that bail a little bit higher, because they're trying to show that they are protecting the citizens of the